In the progression of understanding agency relationships and the importance of disclosure and consent, it becomes vital to examine conflicts of interest, particularly those that cannot be waived under any circumstances. A conflict of interest arises when a licensee's personal, financial, or professional interests could compromise their ability to represent a client with undivided loyalty. Arizona real estate law, specifically ARS Section 32-2153, AA3, and Commissioner's Rule R4-2, 8-1101A emphasizes that licensees must always act with honesty, integrity, and fidelity to their clients' interests. When a situation exists in which a licensee cannot maintain impartiality or fulfill fiduciary duties, the conflict becomes unwaivable, meaning no amount of disclosure or consent can make the representation lawful or ethical. In Arizona real estate practice, the most common example of an unwaivable conflict of interest occurs when a licensee attempts to represent opposing parties in the same transaction without proper neutrality. For instance, a single agent representing both a buyer and a seller without informed written consent, under R4-28-1101F, would be engaging in dual agency without authorization, which violates both statutory and ethical standards. However, some conflicts go beyond mere procedural violations. They create an inherent impossibility for fair representation. An example would be an agent who stands to benefit directly from one side's gain or loss, such as when a licensee purchases their client's listed property for themselves or for a family member, without full disclosure and arm's-length negotiation. Even with disclosure, such situations often cannot be ethically cured because the agent's personal gain conflicts directly with their fiduciary duty of loyalty to the client. Consider the following scenario. A listing agent learns that the seller's property is significantly undervalued and decides to purchase it personally or through a family trust before disclosing its true worth. Even if the agent informs the seller of their intent to buy, this transaction would still represent an unwaivable conflict of interest because the agent cannot be expected to advocate fairly for the seller while negotiating against themselves. The same principle applies to a buyer's agent who secretly holds a financial interest in a competing property or stands to gain from a transaction that disadvantages their client. These situations undermine the foundation of trust on which fiduciary relationships are built and constitute clear violations under ARS Section 32-2153B3 and R4-28-1101E. Another unwaivable conflict arises when an agent's professional duties to two separate clients directly oppose each other. For example, if one client's success in a transaction necessarily harms another's, such as when a broker represents two buyers competing for the same property. Continuing to act for both would create an unmanageable ethical conflict. Even if both buyers consent, the broker cannot provide each client with undivided loyalty and fair negotiation. In such cases, the broker must withdraw from representing one or both parties to preserve impartiality and compliance with fiduciary obligations. Arizona case law reinforces this principle. In Barnes v. Lopez, 1985, the Arizona Court of Appeals emphasized that fiduciary duties require undivided loyalty and the avoidance of any position where personal interests or divided loyalties conflict with the client's welfare. This precedent clarifies that when the agent's self-interest or divided duty prevents objective service, the conflict is inherently unwaivable. The ADRE further interprets this through commissioners' enforcement actions, holding that even the appearance of impropriety can erode public trust and justify disciplinary measures. Disclosure and consent cannot remedy an unwaivable conflict because the licensee cannot simultaneously serve the client's best interest while pursuing their own advantage or balancing mutually exclusive duties. For instance, no disclosure can make it acceptable for an agent to conceal a higher offer on their client's property to facilitate a sale to their own buyer. Similarly, no consent can authorize a licensee to withhold material information or misrepresent facts to one party for the benefit of another. These situations are not matters of misunderstanding or poor communication. They represent fundamental breaches of ethical and legal obligations. In addition to financial or transactional conflicts, personal relationships can also create unwaivable conflicts. For example, if a licensee is romantically involved with a buyer while representing a seller, or vice versa, that relationship inherently compromises the agent's ability to act impartially. Even if disclosed, the emotional and personal ties make objective advocacy impossible. The same applies when an agent's immediate family member has a direct stake in the transaction. In these cases, the appropriate and lawful action is to refer one party to another qualified licensee or brokerage, ensuring that all sides receive fair representation without bias. A licensee who finds themselves in a position of unwaivable conflict must immediately withdraw from representation or reassign one of the parties to another agent under the supervision of the same employing broker. If appropriate, failure to do so may result in disciplinary action, license suspension, or revocation. The ADRE views such conflicts as serious ethical violations because they undermine public confidence in the integrity of the real estate profession. Review summary. Unwaivable conflicts of interest occur when a licensee's personal, financial, or professional interests make it impossible to act with undivided loyalty or impartiality toward a client. These conflicts cannot be remedied by disclosure or consent because they destroy the fiduciary foundation of the agency relationship. Examples include buying or selling property for personal gain without independent representation, representing both sides in a transaction where loyalty is divided, or maintaining personal relationships that impair objectivity. Under ARS Section 32-2153 and R4-28-1101, licensees must avoid and withdraw from such situations to maintain compliance, protect clients, and preserve public trust. Discussion. Why are some conflicts of interest considered unwaivable? Answer: because they create situations where a licensee cannot act with impartiality or undivided loyalty, making it impossible to fulfill fiduciary duties even with disclosure or consent. What should a licensee do upon identifying an unwaivable conflict of interest? Answer: the licensee must immediately withdraw from representation or transfer one of the clients to another agent to prevent bias and protect client interests. Can disclosure cure all conflicts of interest? Answer: no. Some conflicts, particularly those involving personal gain or divided loyalty, are inherently unwaivable and cannot be ethically or legally resolved by disclosure alone. Closing remarks. Understanding unwaivable conflicts of interest protects both clients and professionals from the erosion of trust that can damage the real estate industry. These conflicts represent the fine line between ethical representation and self-serving behavior. A responsible licensee recognizes when impartiality is impossible and takes immediate corrective action by withdrawing or referring clients to other qualified professionals. By doing so, agents uphold their fiduciary duties and preserve the integrity that defines Arizona's real estate profession.